Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. Last week, the plaintiffs in the ongoing Flores litigation submitted their response to the order to show cause to the court, a week after the government submitted their own document. Here to discuss where the Flores settlement agreement stands and what to expect next is Lindsay Harris, Legal Fellow for the American Immigration Council. Lindsay, thank you for joining me. First, let's step back. Can you describe the Flores litigation and why there was an order to show cause?
Sure. So the Flores litigation comes out of a lawsuit from 1985, so 30 years ago at this point, where immigrant children, suit was brought on their behalf against the government because they were being detained in secure, unlicensed facilities. So in 1997, the government actually entered into a settlement agreement whereby they agreed not to do that anymore. Now, in the summer of 2014, the government began detaining immigrant children and their mothers again, first in Artesia, New Mexico, and now we're seeing 3 facilities in Berks County, Pennsylvania, Dilley, and Karnes City, Texas. Because of this, the plaintiffs brought suit in February 2015, alleging that the government had breached the contract, the settlement agreement. There was a hearing, and then the parties tried to negotiate, and settlement negotiations failed in July. Because of that, the judge stepped in July 2015 and issued an order to show cause. This was basically a ruling in which the judge made her finding that the government had in fact breached the settlement agreement, that they could no longer continue to hold children in these secure, unlicensed facilities. And she said that, furthermore, the children should be released, preferably to a parent, including the parent with whom they crossed the border with, unless that parent was a significant flight risk or they posed a threat to national security, and those 2 issues couldn't be mitigated by a reasonable bond being set or by the conditions of release. So the judge then asked the government to respond. She gave them until August 3rd. They got a quick extension until August 6th to respond and say why they shouldn't comply with that order within 90 days.
Thanks, Lindsay. What were the government and plaintiffs' responses?
Sure. Well, the government actually filed a fairly lengthy response, but their argument was essentially that things had changed since the hearing in April 2015. So in May 2015 and later in June, the government announced by a press release new policies, basically saying that they would actually let children and mothers who had passed the first test to establish eligibility for asylum, so a credible fear test or a reasonable fear interview for other forms of protection here in the U.S., they would let those women go as long as they had a verifiable residential address. So in their filing they said things have changed, we don't have a blanket policy of detaining these mothers and their children, we're actually able to go through this process in an average of 20 days, and so the court should revisit their order and basically we're in compliance with the agreement. They also argued that a number of the terms that the judge had interpreted, secure facilities for example, should be revisited, and also that the agreement really didn't apply to all minors. Instead, it applies only to unaccompanied minors rather than children arriving with their moms or dads. Basically, the plaintiffs argue in response to the government that their policies haven't changed and children and their mothers are still being detained for lengthy periods of time, often more than a month. And that's in part caused by the defendants, the government's own policies. So a lot of the declarations talk about the delays in triggering the credible fear or reasonable fear interviews, or in giving the results of those interviews to the women, which then results in a notice to appear being issued so that these folks can actually get before an immigration judge. The plaintiffs also responded to the government's argument that they needed to hold children and their mothers in detention for a period of time in order to facilitate access to counsel and medical care. On the access to counsel point, plaintiffs filed declarations and arguments to show that, in fact, holding these children and mothers in detention facilities is impeding their access to counsel. First, the facilities are located often fairly far away from where you would most often find immigration attorneys to provide counsel and representation. And then second, the plaintiff's brief details a number of practices where the government agents are actually interfering with access to counsel and not denying access to the facility for certain attorneys and legal volunteers, and other issues around access to counsel. And then second, on the medical concerns, the government argued in their brief that detaining families for a period of time allowed them to do medical screenings and provide vaccinations. The plaintiffs provided a number of declarations talking about the medical conditions, which have been the subject of a complaint with the DHS Office of Civil Rights and Civil Liberties, that the declarations show that actually children and their mothers are more likely to have existing medical and mental health conditions exacerbated in detention, or to acquire new medical conditions caused by the conditions of their confinement, or to contract a communicable disease or a virus while in detention. So those 2 points were really roundly discounted by plaintiffs in this filing. Plaintiffs also argued that the government is not required by Congress to put mothers and children into expedited removal proceedings. Nothing in the law says that this is required, and the government could in fact just go ahead and issue notices to appear and parole women and children into the U.S. to undergo their removal proceedings in immigration court. The government has actually been doing this and did do it for a period in July. So the evidence submitted with plaintiffs' brief supports that, and there's nothing that requires the government to go through this expedited removal process.
What should we expect to see next?
Well, the judge in this case very quickly denied the government's request for oral argument, so she doesn't want to see any more briefing or arguments made in this case. She's ready to issue her decision. So we anticipate that she will in fact issue that order very shortly, likely before August 24th, a week from today. Then the government could, of course, appeal. We hope that they will respond to pressure from advocates and from Congress. 178 Democrats have called on the government to end this policy of family detention, and we hope that they will quickly comply with the judge's order.
Thanks, Lindsay, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.